want to be bringing to the conversation Jessica Levinson, who's a professor at Loyola Law School.
Yeah, Professor Levinson, always good to have you. Thank you so much. Last time we talked to you, this is before the indictment was unsealed. Now we know it's in the indictment, but much to what Phil just brought up, why now? What's different here with Trump than any other politician who has tried to, so to speak, bury their skeletons in a closet before? Why now?
Well, I think why now, I guess a two-part question. Why now? Because we have a new district attorney in Manhattan, and he looked at this case and he looked at it fresh, and he looked at the depositions, he looked at the evidence, he decided to present that to a grand jury, and the grand jury voted to indict. And he thinks there's enough here to move forward. You know, the crux of this, of course, is the falsification of business records. Is that he claimed that he was, that these were legal expenses when he was paying Michael Cohen back. They, of course, were not legal expenses. They were repayments for the hush money. And then Michael Cohen himself has admitted that these payments actually violated federal law because they should be viewed as campaign contributions. Now, that's the why now that we know, is that basically the district attorney's office changed hands, and we have a district attorney who looked at the evidence from a fresh perspective.
You touched on it a little bit there, but can you sort of break down why this isn't a misdemeanor? Because to make it a felony, you need to have proof of trying to conceal another crime. Donald Trump is not being charged for another crime, and there wasn't another crime explicitly laid out.
Exactly. To the disappointment of some people, including myself, I would have loved to see the section that they pointed to, and here's the other crime. So, Alex, as you mentioned, falsification of business records, that's a misdemeanor. No matter how many counts it is, it can be one count, it can be 34 counts, but falsification of business records in New York is a misdemeanor. How does it get pumped up to a felony? If the prosecutor can show that there is intent, which is always difficult, intent to commit another crime or to conceal another crime. Now, in the statement of facts, not the complaint, but in the statement of facts, the district attorney said, basically, we think there's enough here for a violation of New York election law, potentially federal election laws, and that these payments were mischaracterized for tax purposes. So there you have potentially state and federal tax violations. And that's how you move from the misdemeanor to the felony.
But then why not charge him for those?
Why not charge him for those is, I think, something that we are going to hear asked of the DA a lot more in the next few days. I mean, his response when a member of the press asked him something akin to that was basically, we've fulfilled our duty here. Now, I'll say there's some complicating factors. If you charge the former president for violating New York election law, I think the complicating factor is that he was a federal candidate. There is a provision of New York law, and he referred to this, that basically says you cannot engage in an unlawful conspiracy to try and get somebody elected. Now, here's the complicating factor if he relies on federal law. He is a state prosecutor. And so we're talking about a federal candidate, but he's a state prosecutor. And I think that the New York Code envisions that you can hook this to a federal crime, but there's not a definitive statement on that. So there are a couple of thresholds here for the prosecutor to have to cross.
For the critics who say this is a prosecutor's overreach, what do you say?
So I would say that this is well within prosecutorial discretion. And what we see here, if you step back, it's not, in my mind, from my perspective, this isn't about bookkeeping. It's not an accounting error. All of this is important to us, members of the public, because of what the district attorney said in the beginning of that statement of facts, that this was a plan to try and prevent the American public from finding out information that the president thought would be damaging, that he sat down with Michael Cohen and David Pecker, the former publisher of the National Enquirer, and they made a decision that they were going to try and catch and kill these stories. And they made the decision to do that in order to affect the election. And that's where the election laws kick in, and that's why we have the conversation about the election laws at all.
So the next hearing that Trump is supposed to be at is in December. There was some discussion about a trial potentially being in January, which of course would be right smack dab in the middle of the presidential primary campaign. What are the chances that this goes to trial? And what are the chances it goes to trial then?
Goes to trial then is the easier question, so I'll answer that one first. And I think the answer is very slim, right? This is an accelerated timeline. I do not expect this to go to trial in 9 months. Now, what are the chances it goes to trial at all? I mean, there's basically two tracks here. So on one track, there's a plea deal that's offered, and the former president takes it. They bring this down to a misdemeanor, and he says basically to himself and to his base, I can sell this. I can say that it wasn't worth my time. I can say it was a bookkeeping error, and I needed to move forward, and I needed to move forward with the campaign, and that's why I took the plea deal. There's another track where the judge dismisses some or all of the complaint here. Now, I think that Trump will make an argument that the statute of limitations has run. I don't think it has, because there's an exception if you're continuously out of the state. I think that Trump's legal team will make the argument that the prosecutor, as we just talked about, doesn't have the power to hook this falsification of business records onto another crime. You could potentially see a dismissal on that. And I think the former president will argue that he just didn't form the intent to commit or conceal any of these more serious crimes. And so there's a chance that all or some of the case could be dismissed before trial, as there always is.
Well, we'll be watching, as we like to say, and we appreciate you. It's a historic day, and we know that you're very busy, and you have a lot of options to lend your expertise and perspective. So thank you for being with us tonight, Jessica Levinson, Loyola Law School professor.